Well, we now have the pleasure of speaking with Katie Miller. Katie has held a range of leadership positions across the legal landscape, including at the Law Institute of Victoria and Victoria Legal Aid, and she's currently the Deputy Commissioner at IBAC. Katie brings to the table a real unique perspective on the interaction between legal innovation, technology, and the legal assistance sector. So we really are privileged to have Katie here today. Thank you so much for coming along.
My pleasure. Thanks for having me. I think that community justice organisations face a range of challenges that are not unique to the technology challenge, but will be challenging for them when they look to innovate and start changing and improving their services. And they are in some ways the age-old problems. Community justice services tend to be underfunded. They have much more demand than their funding accommodates, and it means that a lot of organisations are stuck in this challenge of how do we serve the demand that exists today, let alone how do we plan for the demand that might be happening in the future. And so I think just that continual busyness means that you are faced with the real challenge of, can I afford to give time today to figure out how to serve more people in the future, if that means sacrificing the time that I could be spending today with somebody who has a real need at this moment in time. So I think just the time challenge, the workload challenge is challenging. I also think that the way that services are funded is largely to provide services, not to do research and development and improve how the services might be delivered. So organisations have a real challenge of, well, how do I find the space, the time, possibly funding to be able to work on these new sort of ways of practicing law. Even though they were in some ways one of the, maybe not the first disruption in the legal sector, but they were a significant disruptor in the legal sector when they were created in the 1970s. I think whether it's because of that or something else, they've actually become, I think, quite cautious about, I guess, their place in the legal sector. I don't know why that is, but I've often noticed when engaging with community justice organisations that they are the model of model litigants. That may be because of the sort of people that they attract, that they genuinely want to do the right thing and they fundamentally believe in the rules of law and want to abide by those. I don't know whether it's also because they were so new and sort of treated with scepticism when they were originated in the 1970s, that's become a cultural thing where they don't want to do anything that looks too different because they'll be criticised as no longer acting like legal organisations. But I definitely do sort of experience when I talk to community organisations a bit more of a conservatism than you might find in other parts of the legal sector. I think one of the things that the Legal Services Commissioner is already doing is really sort of announcing to the sector that she is open for business and that this Legal Services Commissioner is absolutely supportive of innovation and looking at how lawyers can change the way that they do things, particularly when that is about increasing access to justice. So I know that this Legal Services Commissioner has sort of said, look, if you're thinking of doing things, come and talk to us early so that we can tell you if we think that it's consistent with legal regulation or if it's something that needs some further thinking. So I think that statement of innovation is consistent with our professional obligations is a really important leadership signal the Legal Services Commissioner is doing. I think the most important part of this is to engage with your users. So rather than making assumptions about what technology clients may have available to them or what their needs are, actually go out and ask them. And I think that in some ways, if I was to look at the innovation that has had the most impact on the legal sector more broadly, it is, I always laugh when I think of it as an innovation because in some ways it's not very innovative. Talk to your clients, listen to your clients. It sounds ridiculous saying it, but in fact, when we look at a lot of the innovations that have been successful in the last 10 years, it has started with talking and listening to clients about what they need, not what we have to offer. I am a fan of ODR. I'm a fan, essentially, if you go right back, I'm a fan of appropriate dispute resolution. We have many, many more tools with how we can resolve disputes in the modern age, much more than in the 1970s. And I think that we should be constantly looking at what is the right tool to solve this particular problem. There will be a number of problems where ODR is the right tool for the job. And that might be to do with user preference, it might be to do with location, it might be to do with the timeliness with which a dispute needs to be resolved. There will be lots of opportunities or lots of problems that ODR is the right tool to solve. Equally, there will be problems that are not appropriate for ODR. And I think that in some ways ODR is just the next phase of the appropriate dispute resolution conversation, where we say, let's look at the problem, let's look at the parties, and let's actually pick the solution that suits them. I think it can have applicability in the family law space. I mean, I'm not a family lawyer, so I've certainly deferred to the greater wisdom and knowledge of people who are family lawyers or who might be using the family law system. But I think, look, just as a matter of theory, I think absolutely it has the possibility to help some clients. So I mean, I know that family law has been an area where appropriate dispute resolution has been embraced in large numbers, and different types of appropriate dispute resolution. So I think, where you're currently using shuttle mediation, ODR is another opportunity. I think that where parties are not represented, I think that ODR presents some real opportunities, because you've got the possibility of as part of the ODR process, having points along the way where people can access experts or can access written information, can take the dispute at their own pace. I think all of those are features that work well for people who are not being supported by a professional. I think that ODR will generally work well for smaller disputes because of the cost savings. And some of the work that went into developing VCAT's ODR pilot showed that there's a lot of user preference about this as well. And of course, if you're living your life digitally, then you're probably going to want to solve your disputes digitally.
Yeah, great. You mentioned the word champion before, and I'm keen to get your thoughts on that a little bit further in terms of how do we support innovation champions within the community justice sector?
I think there's a few things that people with good ideas need to bring that to fruition. In some ways, you could actually sort of think about it in terms of a life cycle. So the idea is really just the conception. In terms of what is needed to bring that to birth and then, surviving and thriving, there's a lot that needs to go into that. I think that when we think about these things, often we sort of go straight to it's money. And I would say that there's lots of places that people with good ideas can find money. Don't get me wrong, we'd like more of those places, but you don't just have to fund this through the legal sector or through legal organisations. So I would say to people who want to support innovation, don't think that your only value is the money that you can bring. I think that information is one of the most significant things that the legal sector can bring to supporting good ideas. I think there's a lot of really talented technologists out there who want to help, who want to be part of building access to justice. What they don't have is the tacit knowledge of lawyers. And so I think partnering with technologists who have the tech know-how, with lawyers who have the legal know-how, can help to bring these ideas to fruition. Part of that means that I think one of the best ways we can support legal organisations to innovate is to actually start thinking about, well, what is it about our environment that stops us just giving the information tomorrow? And we absolutely do have some real things that need to be worked through. We owe obligations of confidentiality to clients. We have to respect privacy. So it's not just a matter of opening the doors and saying, here's the information, come and get it. So I think if we could start thinking about, well, what are the processes and mechanisms we need to put in place to be able to respond to these requests in a positive way, that's work we should be doing now rather than waiting for the request, because by the time the request comes, it'll be too late. Oh, well, I think that Justice Connect is currently a leader. I think that the work that Kate Fazio is doing is amazing. So I think the Gateway project is great. And what I love about the Gateway project is that she's not just stopping there. It is innovation not just in product, but also in process. Justice Connect have deliberately started with one problem, one solution, and they've implemented it and it's been done well, but then they haven't stopped there. They have constantly looked at how can we expand this, how can we bolt things on, and I think, again, going back to where is the real innovation coming from, it's not necessarily in the products that are produced, it is in the process. And I think that idea of start small, get a minimum viable product, trial it out, get it embedded into your mainstream way of working, and then build on that is how we are going to achieve sustainable innovation.
Fantastic. Very well said. Thank you so much.
Thank you.